Welcome, welcome, welcome to the deep dive. This is why we take a stack of source material and slice right through the noise to get to the most important insights, leaving you feeling sharper, more informed, and maybe even ready to ace that upcoming exam.
And today, we are tackling a truly foundational question for UK copyright law. It's really the gateway to understanding everything else.
Mm.
What makes something eligible for copyright protection in the first place? What are the absolute ground rules that mean a creative work gets that legal shield?
Exactly. It's like before you even think about whether someone copied your work, you first have to ask, did your work have copyright to begin with?
Hmm.
And just to be clear up front, this deep dive is based on some fantastic educational materials generously made available to students by the University of London. We really want to give a huge thank you to them for compiling these resources.
Absolutely.
This deep dive is intended purely for educational purposes, to help you wrap your head around these key concepts.
And we're delighted to bring this deep dive to you today, powered by Sinorbit Academy, Sri Lanka.
For any of you out there wading through this material, especially if you're prepping for exams, understanding copyright subsistence, that's the official term for whether copyright exists in a work, is absolutely essential.
It really is.
Get this right, and the rest of copyright law just makes so much more sense. So if you are facing an exam, we wish you the very best of luck.
Definitely. Our mission today is, well, it's to guide you through the core requirements outlined in the materials, pulling out the key provisions from the Copyright Designs and Patents Act, 1988, we'll call that the CDPA, and critically, showing how UK courts, and also the Court of Justice of the European Union, the CJEU, have interpreted and, frankly, sometimes wrestled with these rules through some really pivotal cases.
We're going to unpack the specific types of works the law protects, those must-have ingredients like originality and being in a fixed form, how a work actually qualifies for UK protection based on, who made it or where it was first shared, who the law sees as the creator and the first owner, and they're not always the same person, which is crucial.
Yes, very important distinction.
And briefly, how long that protection typically lasts.
Ready to jump in?
Let's do it. So, right from the start, the material tells us UK copyright is a property right. Section 1 of the CDPA confirms this. And here's something fundamental that sets it apart from, say, patents or registered trademarks. You don't need to register it at all.
That's a huge point. Copyright protection is automatic. The moment a work is created and meets certain conditions, the law says, poof, copyright subsists. There's no central register you need to file with, no forms to submit to get that basic protection.
Okay, automatic is powerful. So what are those conditions then? What makes this magic happen?
Well, the source outlines three main hurdles. A work generally needs to clear for copyright to subsist under UK law. First, the work must be original.
Okay.
Second, it needs to be recorded in some kind of permanent form, though we'll dig into a notable exception to that later on.
Right.
And third, the author of the work needs to be what the law calls a qualifying person.
Original, fixed, and a qualifying author. Simple enough on the surface, but I have a feeling original especially isn't quite as simple as it sounds.
Oh, absolutely not. That's where, a lot of the case law really comes into play. But before we get deep into those, there's another absolutely crucial distinction the source highlights right at the beginning, and it causes a lot of confusion if you don't grasp it. The difference between the author and the owner of the copyright.
Ah, yes, the creator versus a rights holder, I see.
Precisely. The author is the human being who actually creates the work. The writer, the painter, the composer. The initial owner of the copyright might be that author, but very often, because of things like employment contracts or commissioning agreements, the initial owner is someone else, like a company or maybe the person who hired the creator.
So you can create something, be the author, but the copyright automatically belongs to your employer right from the get-go.
Exactly. In certain circumstances, yes. And that distinction is vital because it's the owner who generally has the rights to do things like copy the work, adapt it, issue copies to the public, and, crucially, to sue if someone infringes those rights. The author gets the credit, perhaps, but the owner controls the rights.
Okay, author is the creator, owner is who holds the economic rights, and they can be different people.
Got it. The source also mentions the CDPA gives us a list of categories of works, but understanding them really requires looking at the case law, doesn't it? How the courts have applied and interpreted these categories over the years.
That's absolutely key. The statute gives us the skeleton, if you like, but the case law provides the flesh and blood. It shows how these abstract legal definitions apply to the messy reality of creative works, especially as technology keeps changing.
And just a quick note on duration, how long copyright lasts. The source mentions it can be complex, but for our purposes today, and likely for your exam purposes too, we're operating on the assumption that the works we're discussing were created after the CDPA came into force in 1988. Yes, that helps simplify the duration rules we'll touch on later by avoiding some older historical complexities. Focusing on the post-1988 regime makes it much clearer to grasp the core principles under the current law.
Right. So that's our starting point. Automatic property right requires originality, fixation, and a qualifying author. And always remember that distinction between author and owner. Now let's dive into the very first hurdle, fitting into one of the specific categories of work protected by UK law. These are listed in Section 1 of the CDPA and detailed in Sections 3, 4, 5A, 5B, 6, and 8.
This is what we call the closed list system in the UK. It's quite distinctive. For a work to receive copyright protection under the CDPA, it must fall squarely into one of these predefined categories.
Wait.
You can't just say, oh, it's creative, so protect it. It needs to be identifiable as, say, a literary work or a dramatic work, a musical work, an artistic work, a film, a sound recording, a broadcast, or a published edition. One of those 8.
So if a brilliant new form of creative expression emerges that doesn't fit neatly into one of these 8 boxes, no protection, is that right?
Well, that's the traditional UK position under the CDPA, yes. However, this is where things get interesting, particularly because of the UK's historical relationship with EU law. There's been significant tension here. The underlying principle in EU copyright law, as interpreted by the CJEU, sort of suggests that any work that is an author's own creative expression should potentially be capable of protection. And that idea arguably challenges the rigidity of needing to fit into a closed list.
So the EU perspective is potentially much broader, like any creative expression could be a work.
That's the implication, potentially. UK courts have acknowledged this tension, even if they haven't always had to deliver a final ruling on it. You see references in cases like SS Institute Inc. v. World Programming Ltd. and more recently Response Clothing Ltd. v. the Edinburgh Woolen Mill Ltd. They noted the potential doubts about whether the CDPA's closed list system is fully compatible with these broader EU concepts.
And this brings us neatly to a fantastic and frankly quite famous CJEU case. Lavella Hengelo BV Smiled Foods BV C31077, the case about the taste of cheese.
Yes, it sounds quirky, doesn't it? But it's legally very significant. The Dutch court asked if the taste of a cheese, specifically hexancas, could be protected by copyright under the EU Information Society Directive. And the CJEU used this opportunity to give some really crucial guidance on what constitutes a work under EU law.
And what did they say defines a work, then?
The court set out 2 cumulative conditions, so you need both. First, the subject matter must be original, meaning it's the author's own intellectual creation. That's the standard EU test for originality we'll definitely deep dive into later.
Okay.
Second, and this was the crucial hurdle for the cheese taste, it must be expressed in a manner that makes it identifiable with sufficient precision and objectivity.
Identifiable with sufficient precision and objectivity.
Right.
Why did the taste of cheese fail that test?
Because taste is inherently subjective and variable, isn't it? It depends entirely on the individual consumer's perception, their age, their preferences, their food habits, even the environment or context in which they taste it. The court basically said because it can't be identified precisely and objectively by others, it couldn't be a copyright work under EU law.
That makes perfect sense when you think about it that way. What tastes amazing to one person might taste completely different or even, unpleasant to someone else.
Exactly.
And the source notes this reasoning would likely apply to perfumes too, right? Which have faced similar legal questions in other countries.
Yes, the logic seems directly applicable. The level of judgment really reinforced this idea that the concept of work is an autonomous concept within EU law.
Right.
That means its definition isn't left entirely up to individual member states.
Right.
And even though the UK has now left the EU, this ruling, and others like InfoPack on originality, continue to influence UK law. This happens either through the principles of retained EU law or simply because they represent the modern direction of travel in interpreting concepts embedded in international treaties, like the Berne Convention, which the UK is definitely still party to. So that tension between the UK's closed list and the potential for a broader concept of work remains relevant.
Fascinating. So while the CDPA still technically presents a closed list, the judicial thinking influenced by this EU jurisprudence might subtly push courts towards a more flexible interpretation of those categories, maybe to accommodate new forms of expression that are clearly original but don't fit easily.
That's the potential dynamic, yes. But for now, the starting point is definitely walking through those specific categories listed in the CDPA. That's the framework we have to work with.
Okay, let's do that. First up, literary works under Section 3 of the CDPA.
Right, Section 3.1 gives us a broad definition. It includes things like tables, compilations, computer programs, and databases. Very importantly, it explicitly excludes dramatic and musical works. They're separate categories.
Okay.
And it can be written, spoken, or even sung, as long as it's recorded in some way. And writing itself is defined very broadly in Section 178 of the CDPA to include pretty much any form of notation or code, on any medium.
So it's definitely not just novels or poetry. The classic case here is University of London Press v. University Tutorial Press from 1916.
Yes, a foundational case. Peterson J. gave a really broad interpretation. He said a literary work is simply something that is written or printed. And crucially, he stated that the quality doesn't matter at all. It doesn't have to be literature in the artistic sense.
Right. University of London Press v. University Tutorial Press. Quality irrelevant. And this is why really mundane things can get literary copyright. The source gives examples based on case law. Football pools coupons, that was Ladbroke v. William Hill TV listings, exam papers, which was the issue in the University of London Press case itself, and even things like telegraphic code.
Right. The focus in those older cases was very much on the skill, labor, and effort that went into creating the written text, no matter how perhaps uninspiring it might seem. However, there is a minimum threshold. Some things are just too trivial, too slight.
Like what sort of things?
Well, song titles, for instance. Francis Davey, 20th Century Fox held song titles weren't substantial enough to be protected as literary works. Invented word trademarks, like the word Exxon, weren't literary works in Exxon Corporation v. Exxon Insurance Consultants. Let's say that again, Exxon Corporation v. Exxon Insurance Consultants. And purely everyday factual information, like diary entries, just listing appointments, wasn't protected in Cramp v. Smithson.
Okay.
These were generally seen as lacking sufficient substance or original expression, even under that older, lower UK originality test.
But headlines and extracts from news articles can be protected. You mentioned newspaper licensing agency v. Meltwater Holding BV earlier.
Yes, that's right. That case confirmed that even short snippets can be capable of protection if they meet the originality requirement. And as we'll see, that originality requirement has evolved now to include more of a creative element.
Okay. Moving on, dramatic works, also under Section 3 CDPA. This includes dance and mime, as well as traditional plays.
Yeah, the case law here emphasizes that a dramatic work needs to be capable of presentation or delivery. There's an older case, Fuller v. Blackpool Winter Gardens, that points to this. It's fundamentally a work of action intended to be performed for an audience. That came through in Nerosian v. Arcs Ltd. Let's repeat that, Nerosian v. Arcs Ltd.
That requirement for presentation for performance explains why video games aren't considered dramatic works, doesn't it? There was the Nova Productions Ltd v. Mazuma Games Ltd case. Because they're interactive, not a fixed performance sequence.
Precisely. And TV formats. Well, they are notoriously difficult to protect as dramatic works. Generally, they are seen as mere ideas or perhaps lacking sufficient detail to be a work of action. The classic case here is Green v. Broadcasting Corps of New Zealand, involving the format for the show Opportunity Knocks.
Ah, yes.
It was held not to be a dramatic work because it wasn't fixed in writing, with enough precision to outline a coherent sequence of events. Green v. Broadcasting Corps of New Zealand.
So you can't copyright the idea of a talent show, basically.
Essentially, no. Not as a dramatic work, anyway. However, the Banner Universal Motion Pictures Ltd v. Endemol Shine Group Ltd case from 2017 offered maybe a glimmer of hope. Snowden J. suggested that a format could potentially be protected if it had clearly identified distinguishing features connected together in a coherent, repeatable framework.
So more than just a concept.
Exactly. It's still a high bar, though. It requires the format to move significantly beyond a mere idea to a properly structured, expressible framework that dictates the action.
Okay. Next, musical works. Section 3 CDPA again. This is defined as a work consisting of music exclusive of words or action. And the source makes a key point here. In the UK, the music and the lyrics have separate copyrights.
Yes, this is a crucial distinction, especially compared to some other systems. The composer owns the copyright in the music, the tune, the harmony, the rhythm. The lyricist owns a separate literary copyright in the words. They might be combined in a song, of course, but they are distinct legal works initially.
And the threshold for musical works seems incredibly low. A 4-chord sequence was apparently enough in Lawson v. Dundas. Adding a simple drum accompaniment qualified in Bang Boy v. Reed.
Yes, minimal original musical material can qualify. However, purely vocal elements, like a singer's particular pitch or phrasing or timbre in a performance, weren't considered separable enough from the underlying musical work to get their own musical copyright in Coffey v. Warner Chappell Music Ltd. The performance might have separate rights, but not as a musical work itself.
The source also notes that music doesn't have to be formally written down as sheet music to qualify. Hadley v. Kemp suggested a musical work composed in someone's head was put into permanent form just by making a demo tape. Let's repeat that. Hadley v. Kemp.
That case touches on both fixation, the recording requirement, and originality in composition. The source also refers to Sawkins v. Hyperion Records for a detailed look at musical copyright. That's Sawkins v. Hyperion Records. And an activity note in the source compares Sawkins to Hadley v. Kemp to get you thinking about the performer's role versus the composer's role. It hints at the nuances of what counts as the protectable musical work versus the performance or arrangement of it.
Right. Okay. Artistic works, covered in Section 4 CDPA. This is a huge category, isn't it? Both 2D and 3D works. The list in Section 4.1 gives examples: paintings, sculptures, drawings, engravings, photographs, buildings, and works of artistic craftsmanship.
And for that specific list, in S14A, paintings, sculptures, drawings, engravings, photos protection exists regardless of any perceived artistic quality.
Right.
Yes. A child's crayon drawing gets the same basic protection as a Rembrandt, assuming all the other conditions like originality are met. Quality is irrelevant for these, just like for literary works.
That's interesting. But there's a limitation mentioned. Section 51 CDPA.
Yes. Section 51 is important, especially in design law. It limits copyright protection for drawings when those drawings are used as the basis for making three-dimensional articles industrially. It's designed to prevent copyright being used to get perpetual protection for functional designs. It links forward to infringement rules, but it's a key statutory carve-out affecting artistic works used in design.
Okay. Let's look at how the courts have interpreted some of these specific terms within artistic work. Painting needs some permanence, apparently. Makeup applied to Adam Ant's face wasn't permanent enough in Merchandising Corporation of America v. Hartbond.
Right, and sculpture has seen important clarification, particularly from the Supreme Court in Lucasfilm Ltd v. Ainsworth. That's the famous stormtrooper helmet case. Let's say it again. Lucasfilm Ltd v. Ainsworth.
Yes. So what was the key point there?
The Supreme Court upheld Manjay's view in the lower court, which was 2009 FSR 103, that the intended purpose of an object is a relevant factor in determining if it's a sculpture for copyright purposes.
So even though Stormtrooper helmet is obviously a 3D object, because its primary purpose was utilitarian, part of a film costume and prop, it wasn't considered a sculpture under UK copyright law.
Correct. It wasn't regarded as a work of fine art in the traditional sense, and its functional aspect was important. It was ultimately held not to be a sculpture, even though the design drawing for it could be protected as an artistic work, specifically a drawing.
Interesting distinction. And drawing is interpreted very widely, you said, not just fine art drawings.
Not at all. Logos, like in Hutchinson Personal Communications v. Hook Advertising, architect's plans, Jones v. London Borough of Tower Hamlets, cartoon characters, King Features Syndicate Inc., VONM, Kleeman Ltd., even technical drawings of machine parts or fashion sketches, they all fall under drawing. And even a tartan fabric design can be both a literary work, the written pattern instructions, and an artistic work, the visual design itself. That was Moon v. Thornburg.
Photographs have had a particularly interesting journey through case law, you mentioned, especially with EU influence.
They have. Historically, the focus was just on whether it was copied. While copyright in a photo doesn't stop someone else photographing the same scene, obviously copying the photo itself requires substantial taking from the original, as seen way back in Bauman v. Fussell. A more modern summary is in antiquesportfolio.com, Ltd v. Rodney Fitch & Co., Ltd.
And then the CJEU case, Eva Maria Painter v. Standard Verlags GmbH, that's C14510 from 2011. That applied the Infopack author's own intellectual creation test specifically to photographs, right?
It did. And this was directly applied in the UK Patents County Court case. Temple Island Collections, Ltd. v. New English Teas, Ltd. by HH8 Burrs QC. Remember that one? Temple Island Collections, Ltd. v. New English Teas, Ltd. This involved that very well-known photograph, Red London Bus, Westminster Bridge, Parliament.
Oh, I know that image. It's everywhere.
Exactly. The question was whether that photograph was original enough to have copyright, given it used iconic pre-existing elements. HHJ Burrs QC, applying the Painter test, found that yes, it was original.
How so?
Based on the photographer's creative choices, the specific motif chosen, the exact angle of the shot, the light, the exposure settings, and importantly, the post-production manipulation. Things like the aesthetic sense, the composition, the visual contrast, like making the butts bright red and the background black and white.
So it's not just about pointing the camera, it's the creative decisions made at every stage, including the editing, that can add up to originality under this test.
Precisely. And the judge found the defendant's similar image had copied these original elements, amounting to a substantial taking, applying the principle from the Designers Guild case about copying the authorial contribution. So Painter and Temple Island are key for understanding photographic originality now.
Got it. Back to Section 4 terms, engraving and etching. These can also apply beyond traditional art.
Yes. Decorative grooves on a plastic frisbee were held to be an engraving in a New Zealand case applied in the UK. Whammo Manufacturing Co. v. Lincoln. Let's repeat that one. Whammo Manufacturing Co. v. Lincoln. And patterns pressed into car mats were engravings in High-Tech Auto Parts Ltd v. Towergate 2 Ltd. Again, it shows how these terms can cover features of manufactured items.
And buildings aren't limited to grand cathedrals or palaces.
No, ordinary houses and shops are included. There are cases like Meckel v. Moff and Havey Sloan confirming this. Copyright protects the architect's plans and potentially the built structure itself as an artistic work.
Now, the phrase the source calls most problematic, works of artistic craftsmanship. It sounds straightforward, needs both artistry and craftsmanship, but the leading case didn't really clarify it.
That's the infamous George Henscher Ltd v. Restawhile Upholstery, Lanks Ltd case in the House of Lords. Repeat, Henscher Ltd v. Restawhile Upholstery. It's considered unsatisfactory because, well, craftsmanship was conceded, so the court didn't define it. And while they discussed artistic, they offered different, somewhat conflicting tests for determining if a work had eye appeal. And their comments were technically obiter dicta anyway, because the original prototype furniture wasn't even available for them to see.
So the courts have struggled to apply this consistently since Henscher.
Yes, it's been difficult. Subsequent cases tried to give more guidance. Merlett v. Mothercare Plock suggested artistic was determined by the author's intention that the work should look nice aesthetically. Vermont v. Bongcrest Ltd said a team could contribute the artistry and the craftsmanship separately, but the quilted bedspreads in that case were found to lack the necessary eye appeal, according to the judge.
And Lucasfilm v. Ainsworth discussed it again in the lower courts.
Yes. Mann, J. and the Court of Appeal provided useful discussion, although ultimately the Stormtrooper helmet wasn't found to be a work of artistic craftsmanship either. A more recent and potentially helpful case is Response Clothing Ltd, the Edinburgh Woolen Mill Ltd, from 2020. Let's repeat. Response Clothing Ltd v. the Edinburgh Woolen Mill Ltd.
What clarity did Judge Hakon offer there? It involved a fabric design, didn't it?
Yes, a sort of wavy stripe fabric. He made several practical findings. A machine can be involved in creating the work. Aesthetic appeal can be appeal to customers, not just fine art critics. And mass production doesn't automatically disqualify something. He adopted a definition from a New Zealand case, Bonds Group, Cody Ltd v. Cook, defining a craftsman as someone skillful who takes pride, and an artist as someone with creative ability producing aesthetic appeal. This provides a more contemporary lens, perhaps, acknowledging that modern craftsmanship often involves machines and commercial intent.
That seems a much more useful test for contemporary items, potentially. Okay, that covers the main authorial works L, D, M, and A. What about the so-called entrepreneurial categories?
Right. Films. First, Section 5B CDPA. Defined simply as a recording on any medium from which a moving image may be produced. The key elements are recording, any medium, and moving image.
And films get dual protection for sound.
Yes, the soundtrack is treated as part of the film, and it's also treated as a separate sound recording in its own right.
And of course, a film is usually a bundle of other copyrights. The script is literary, the music is musical, maybe there's choreography, which is dramatic, drawings or special effects, which are artistic.
Exactly, it's a complex bundle. Then, sound recordings, Section 5A CDPA. Defined as a recording of sounds or are a recording of a literary, dramatic, or musical work from which sounds reproducing the work may be reproduced.
Okay.
Keywords there. Sounds, so not just music, it could be speech, sound effects from which sounds may be reproduced, and regardless of the medium it's recorded on.
So a recording of this very deep dive is a sound recording, just like a music track is.
Yes, and again, sound recordings often contain underlying literary or musical works which have their own separate copyrights.
Broadcasts, Section 6 CDPA. This is about electronic transmission for simultaneous reception by the public or transmission at a determined time.
Yes, and this definition was revised in the CDPA specifically to address online transmissions. It aimed to reverse the effect of cases like Shetland Times v. Jonathan Wills, which had controversially held that simply making content available on a website was a broadcast. Let's say that again. Shetland Times v. Jonathan Wills.
Right, so now online transmissions are only broadcasts if they are simultaneous with a non-internet broadcast or concurrent with a live event or part of a scheduled program service, like an online TV channel.
Exactly. Much narrower now, aiming to distinguish traditional broadcasting from general internet content delivery.
Finally, published editions, Section 8 CDPA. This protects the typographical arrangement of literary, dramatic, or musical works.
The point here isn't the content, it's the look of the page, the layout, the typesetting. It protects the publisher's investment in that aspect of presentation. Crucially, it only subsists if the arrangement isn't just a reproduction of a previous edition's layout, and it's entirely separate from the copyright in the underlying work itself.
So you could get protection for the layout of, say, a new edition of Shakespeare's plays, even though Shakespeare's works themselves are long out of copyright.
Precisely. The layout itself is the work here.
Okay.
But the meaning of edition is quite narrow. It was defined by the House of Lords in Newspaper Licensing Agency Ltd v. Marks & Spencer PLEG. Remember that one? Newspaper Licensing Agency Ltd v. Marks & Spencer PLEG. It refers to the entire published product, like a whole newspaper edition, not just individual articles or sections within it. And this protection is limited to printed editions like books, periodicals, plays, and sheet music. The design of the typeface itself, the font, would be protected separately as an artistic work, a drawing.
All right, that's our closed list of categories. Phew. Literary, dramatic, musical, artistic, film, sound recording, broadcast, published edition. And as we've seen, the interpretation of these is heavily shaped by case law and increasingly influenced by those EU principles, even post-Brexit.
Absolutely. Fitting into one of these boxes is the first essential step.
Which brings us to the second major requirement, and arguably the most debated one, originality. This is required for literary, dramatic, musical, and artistic works under Section 1 CDPA.
Yes, and just to clarify, for the other categories, films, sound recordings, broadcasts, and typographical arrangements, the requirement isn't usually framed as originality in the creative sense.
Yeah.
Their respective sections in the Act, like S.5b4, S.5a2, etc., state that copyright doesn't subsist if they're simply copies of previous works of the same type.
Oh, okay.
So it's more about being the first recording or broadcast or typeset edition of that kind, rather than needing creative originality in the same way as the LDMA works.
That's a key distinction. Originality for the creative works, more like not a copy for the entrepreneurial works. Now, let's revisit that UK originality test, the historical one.
Historically, the test came from that University of London Press case back in 1916. Remember, University of London Press. It was about whether the work originated from the author, meaning it wasn't copied from another source. And generally, putting in sufficient effort, skill, or labor, sometimes called sweat of the brow, though the source doesn't heavily use that phrase here, was considered enough to show that origin.
So the amount of effort was often the focus, rather than creativity.
Often? Yes. It seems that way in the older cases. If you compiled a long list, even if it wasn't particularly creative in its selection or arrangement, the sheer labor involved could contribute to it being considered original under that older standard. However, then the European standard arrived. Author's own intellectual creation. And that fundamentally changed things.
And that came through EU directives first, for specific types of works.
Exactly.
Yeah.
Directives dealing with databases, software, and photographs explicitly required originality based on author's own intellectual creation. But then the CJEU went much further in a landmark case, Infopak International ASV Danske Dagbladsforening, that's C508 from 2009. Remember Infopak?
The case about the newspaper snippet?
Yes,
Yeah.
that's the one. The court ruled that this author's own intellectual creation standard applied not just to databases, software, photos, but to all works covered by the Information Society Directive. That includes literary, dramatic, musical, and artistic works.
Wow.
Their reasoning was largely about achieving harmonization across the EU and aligning with the spirit of the Berne Convention. They essentially said the very concept of a work in copyright inherently implies some level of creativity by an author.
So Infopak effectively introduced a higher creativity-focused bar for originality across the board in the EU, replacing or modifying the pure sweat of the brow approach.
That's the general understanding, yes. UK courts now have to navigate between the older skill and labor concept and this EU-derived author's own intellectual creation test. They often try to find overlap or perhaps interpret the UK test through the lens of the EU one. But the EU test, particularly as applied by the CJEU in later cases, really does seem to require something more than just effort. It requires an expression of the author's creative freedom and personality in making choices.
Okay. Let's look at how this European originality standard has played out for specific types of works based on the source material. Databases, for instance. You mentioned they have the author's own intellectual creation test explicitly in the CDPA now in Section 3.2, reflecting the Database Directive 969.
Yes, and the Football Data Co. Ltd v Yahoo UK Ltd KC C60410 from 2012 is absolutely critical here. Let's repeat that. Football Data Co. Ltd v Yahoo UK Ltd. The CJEU ruled that copyright in a database under the directive only protects the structure, the selection, or arrangement of the contents, not the data contents themselves. And crucially, they emphatically stated that member states cannot grant copyright protection to databases under different, potentially lower conditions than the directive's intellectual creation standard.
So that really struck a blow to the old sweat-of-the-brow approach for databases, where simply compiling data through hard work might have been enough in the UK before.
Exactly. The effort of collecting the data doesn't grant copyright in the database's selection or arrangement unless that selection or arrangement itself reflects the author's own creative choices. This is entirely separate, remember, from the sui generis database, right?
Ah, yes, the other database, right.
That one protects substantial investment in obtaining, verifying, or presenting the contents. It's a different kettle of fish entirely, based on investment, not creativity, but often confused with copyright.
Okay. And software also uses the creativity test.
Yes, that comes from the Software Directive 90250, which is retained in UK law. Software is protected if it's the author's own intellectual creation.
And photographs, as we saw with Painter and Temple Island, also use the creativity test now.
Correct. The Painter case, C14510, showed that even a seemingly simple portrait photograph can be original based on the photographer's creative choices, how they prepare the subject, compose the shot, choose the lighting, the angle, and even any post-production manipulation. It's about expressing their personality through those technical and aesthetic decisions. Painter is key here.
So creativity in the EU sense isn't necessarily about being a genius or creating high art. It's more about exercising personal creative freedom and making choices in how you express something.
That's a good way to put it. And the CJEU has given further guidance on this creative freedom aspect. In BSA v. Ministry of Culture of the Czech Republic, C39309, they said if the expression of something like a graphical user interface, GUI, is dictated purely by its technical function, then there's no room for intellectual creation. The idea and the expression are essentially inseparable.
Meaning if the design is basically the only possible way to achieve the technical outcome, there's no creative choice involved, so no originality.
Precisely. And perhaps most famously for sport, in Football Association Premier League v. QC Leisure, that's C402008 and 42908, the court ruled that sporting events themselves are generally not copyright works.
Why not?
Because the rules of the game leave no room for the kind of creative freedom for the players that would constitute an intellectual creation in the copyright sense.
So while the commentary on the match or the TV graphics or the broadcast itself might be protected, the actual football game unfolding on the pitch isn't a copyright work.
Correct. That's the outcome of FAPL v. QC Leisure. Now, going back to Football Data Co., C60410. Again, remember, the database case, the CJEU, reiterated that intellectual effort or skill in creating the data itself is irrelevant for copyright in the database structure. Adding important significance to data is also irrelevant, and significant labor and skill in setting up the database is insufficient if there is no originality in the selection or arrangement. This directly undermines the older UK sweat-of-the-brow justification for many compilations.
Okay. And another case, Funky Media and NRW GmbH VFRG, C46917, suggested purely informative documents, like military reports, were unlikely to be protected if their content essentially determines their expression, leaving no room for originality. Again, a contrast to the pre-InfoPack UK approach, maybe.
Quite possibly, yes.
No.
That pre-InfoPack UK approach might have protected some such documents based on the compilation effort. Then there's COFML v. G-Star Raw CV, C68317 repeat, COFML v. G-Star Raw. This case clarified that commercially marketed designs, like clothing designs, can be protected by copyright if they meet the two Lavola-Hengelo conditions. They must be original, author's own intellectual creation, and their creative expression must be identifiable with precision and objectivity.
Right.
The source notes this raises an interesting question about whether this fully aligns with the traditional UK work of artistic craftsmanship test, especially those elements of eye appeal or artistic intention from cases like Hensher and Merlet. Does the EU test implicitly require some artistic intention or aesthetic appeal, or just any expression of creative freedom, even if purely functional?
It sounds like UK law is still, grappling with fitting some of its historical concepts into this overarching EU framework. even after Brexit, due to retained law and ongoing influence.
That's a fair assessment. It's an area of ongoing development. And finally, just quickly on EU originality, SI and Brompton Bicycles v. Chedek Get C83388, involving the famous folding bikes, reinforced the principle we saw in BSA. There's no originality if the form or shape of the product is dictated solely by technical considerations, rules, or constraints, leaving no room for creative freedom. The idea and expression merge. This links directly back to the fundamental copyright principle that you don't protect ideas, only their expression.
Okay. So comparing the two standards overall, the European creativity test seems generally understood to be a higher bar than the traditional UK sweat-of-the-brow approach, wouldn't you say? Particularly as evidenced by that football de taco ruling on databases.
Yes, I think that case really highlighted the shift in focus from protecting effort per se to protecting creative expression resulting from freedom of choice.
Now, let's look at originality in some specific practical contexts mentioned in the source. What about revising an existing work? Does that revision get fresh copyright protection, potentially extending the term?
Only if the revision itself is sufficiently original or creative. Minimal changes, like slight modifications to Lego brick drawings, weren't enough for fresh copyright in the Privy Council case Interlego v. Tycho. Remember, Interlego v. Tycho. But substantial revisions to architect plans were found to be enough for a new copyright in the revisions themselves in Calla Homes v. Alfred McAlpine Homes East Ltd.
Okay. What about that Sawkins v. Hyperion Records case we mentioned earlier, where a musical scholar created performing editions of old Baroque music, mostly by deciphering and adding performance instructions, but without actually adding new notes?
This is a fascinating one. Sawkins v. Hyperion Records. The Court of Appeal found copyright did subsist in Dr. Sawkins' editions, seeing his scholarly effort, skill, and judgment in interpreting and realizing the music as sufficient for originality under the UK approach at the time. However, the source explicitly raises the critical question. Would this case be decided the same way after InfoPack and the strong emphasis on authors' own intellectual creation?
It's doubtful.
It's certainly open to doubt. Does arranging or editing old music without adding new creative musical content necessarily involve authors' own intellectual creation? Or is it primarily skill, labor, and scholarly judgment? It's a great example of the potential conflict between the old and new tests.
What about adapting someone else's work entirely, like translating a book or arranging a piece of music?
Well, the translator or arranger will get their own copyright in their translation or arrangement, provided their contribution is original, i.e., it reflects their own creative expression in the choice of words or musical arrangement. However, and this is crucial, by translating or arranging a work that's still in copyright, they're almost certainly infringing the original author's copyright unless they had permission, because they've clearly taken substantially from the original literary or musical work.
Right.
Interestingly, though, the infringer still gets copyright in their adaptation, and they can even enforce their own copyright against a third party who comes along and copies their infringing translation or arrangement. That was established in ZYX Music v. King.
Wait, hang on. So an infringer has copyright in their infringing work? That feels wrong somehow.
It does feel counterintuitive, doesn't it? But copyright protects the expression, regardless of whether that expression was created lawfully or unlawfully in relation to another work. The initial infringement is a separate legal issue from the subsistence of copyright in the new work created by the infringer.
Okay, that's a subtle but important point. Compilations and databases are also complex regarding originality, as we touched upon with Football Dureco.
Yes, compilations of other works, like anthologies or directories, can be copyright works in themselves. Ravenscroft v. Herbert is an example. But obviously you need permission for any underlying works that are still in copyright. Originality in a compilation, traditionally in the UK, depended on the effort, skill, and judgment involved in the assembly. Was it just a random collection, or did it show taste and judgment, like the poetry anthologies in the older Macmillan cases from the 1920s and 1890s? Pre-directive, even things like phone directories got protection based purely on the labor of compiling the lists, as seen in the Waterloo cases.
And that's where the database directive and the UK's 1997 regulations introduced that two-tier system we mentioned.
Correct. Tier 1. Copyright protection for the database itself, but only if the selection or arrangement of the contents constitutes the author's own intellectual creation. That's Article 3 of the directive, now in S.3A2 CDPA. Tier 2. The separate sui generis database right, which protects substantial investment in obtaining, verifying, or presenting the contents. That's Article 7 of the directive, implemented by the 1997 regulations.
And you can have both rights in the same database.
Yes, potentially. Or you might just have the substantial investment but not enough originality in the selection or arrangement to qualify for copyright under that strict EU intellectual creation test.
And the CJEU interpreted the sui generis right quite narrowly in British Horse Racing Board v. William Hill Organisation, Ltd., C2302 from 2004. Let's repeat. British Horse Racing Board v. William Hill.
Yes, they gave a restrictive interpretation to what counts as investment for that right, focusing on the resources used in obtaining, verifying, or presenting existing materials, not the resources used to create the data in the first place. They also looked at what counts as a substantial part being taken. Could it be quantitative, volume of data, or qualitative scale of investment represented? But they took a broad view of what extraction or utilization meant, covering almost any unauthorized appropriation of the contents.
So you only infringe the sui generis right by taking a substantial part, though?
Yes, that was confirmed in BHB v. William Hill and later cases like Direct Media GmbH and Apis Christovich EOD.
So to summarize the database situation, a lot of effort collecting data might get you the sui generis right if it counts as substantial investment, but it won't get you copyright in the database's structure under the current EU-derived standard unless the selection or arrangement itself is creative. And Football Dedico, C60497, hammered this home for database copyright effort in creating data is irrelevant. Only originality in selection or arrangement counts.
It's a complex but very important distinction, resulting directly from the database directives framework.
Okay. Finally, on originality, what about reporters' copyright or copyright in spoken words? Section 3, 2, and 3 of the CDPA state that copyright subsists in literary, dramatic, or musical works unless and until they are recorded in writing or otherwise, and that recording can be done by someone else, even without the author's permission.
This is the mechanism by which spoken words can become copyright works. If a politician gives a speech and a reporter records it using a tape recorder, or takes down very detailed shorthand notes which count as writing, the politician's spoken words are fixed and can gain copyright protection as a literary work with the politician as the author.
Great.
Now, the reporter, through their skill and labor in taking down the words accurately, or perhaps in editing and arranging the report for publication, might also create a separate copyright work in the report itself if their contribution is considered original.
The famous old case is Walter v. Lane from 1900, where the reporter who took shorthand notes of Lord Rosebery's speeches was held to have copyright in his report, Walter v. Lane.
Yes, a House of Lords decision. And that thinking was confirmed much later in Express Newspapers v. News UK in 1990. The interviewee's recorded words were protected literary works, and the journalist's edited report was also protected as a literary work due to their skill, labor, and judgment in selecting and arranging the quotes. Express Newspapers v. News UK. The Sawkins case on musical arrangements also referenced Walter v. Lane positively by analogy.
But here's the question the source raises, letting back to originality. If the journalist is just acting as an amanuensis, a scribe faithfully recording words without adding any creative input or selection, does their contribution really meet the author's own intellectual creation test from InfoPack?
Precisely. The source expresses doubt. It questions whether simply having the skill to take accurate shorthand notes, as in Walter v. Lane, involves sufficient creative freedom to pass the modern EU originality test. It also questions, as we discussed, whether the Sawkins ruling on musical arrangements, which seem to rely heavily on skill and labor rather than overt creative addition, would hold up under a strict InfoPack analysis today.
So the old UK test would probably protect the reporter's skill in taking notes, but the EU test demands creative expression, which might be lacking in pure transcription.
That's the potential friction, yes,
Yeah.
created by the influence of the EU standard. Originality is clearly the battleground, where UK copyright law has been most significantly impacted by European developments and is still seeing the effects play out.
It is definitely a key area to grasp the nuances of.
Absolutely.
Okay, let's move to the third requirement, which is thankfully perhaps a bit less complicated than originality. The requirement of permanent form, or fixation.
Yes, this one's more straightforward. And remember, compared to many other jurisdictions historically, UK copyright law requires no formal registration. That's thanks to adherence to the Berne Convention. Protection is automatic the moment the work is made and fixed, provided it meets the other requirements. Older conventions like the Universal Copyright Convention, UCC, or the Rome Convention for Recordings mention needing copyright notice symbols like the E or the A, but those are not required for copyright to subsist under current UK law, though they can be useful for other reasons.
So no registration needed. But for literary, dramatic, and musical works, Section 3.2 CDPA says copyright subsists unless and until the work is recorded in writing or otherwise.
Exactly. It needs to be fixed in some tangible way so it can be perceived and reproduced. Writing is broadly defined in S.178 to include any form of notation or code, and the phrase "or otherwise" is crucial. It implies other forms of fixation beyond writing are perfectly acceptable.
And the Hadley v. Kemp case supports this, where a musical work conceived in the composer's mind was considered fixed just by making a demo tape. Remember Hadley v. Kemp.
Yes, that case indicates that pretty much any method of recording, audio recording, video recording, digital file notation, is likely sufficient to satisfy the fixation requirement for LDMAs. And as we saw with reporter's copyright, spoken words are fixed if recorded by a tape recorder or transcribed via shorthand notes. Walter V. Lane, Express Newspapers. Satisfying this rule even if recorded by someone other than the author under S.3.23.
What about the other categories? Films and sound recordings seem inherently fixed by their definitions in S.5a and S.5b, which refer to them as recording.
Correct. Their very nature involves fixation. Published editions also need to be published, which implies a permanent record has been made available to the public. Artistic works aren't explicitly mentioned in S.3, but implicitly they must exist in some stable form to be perceived or copied.
So is there any exception to this fixation rule?
Yes. The main exception is broadcasts under Section 6 CDPA. Copyright subsists in a broadcast, even if it's a live transmission that isn't recorded beforehand.
Okay.
Though in practice, of course, most broadcasts are pre-recorded anyway.
So fixation is generally required for literary, dramatic, musical works, and implicitly for artistic works. Films, sound recordings, and published editions are inherently fixed, but live broadcasts are the exception.
That's a good summary. You need something concrete enough for someone else to perceive and potentially copy it from, except for live broadcasts.
Right. Next up, qualification for protection. This is about how a work or its author needs to be connected to the UK or another relevant country to actually get UK copyright protection.
Yes, this is based on the fundamental principle of national treatment, which comes from key international copyright conventions like the Berne Convention, the UCC, the Rome Convention, and the TRIPS Agreement, all of which the UK is a signatory to.
And national treatment basically means?
It means the UK agrees to treat creative works originating from nationals or territories of other member countries of these conventions the same way it treats works from its own nationals or created within its own territory.
So if I'm a national of, say, France, which is a Berne Convention country, and I write a novel, my novel gets UK copyright protection automatically, just as if I were a UK citizen.
Precisely. Sections 153, 160 of the CDPA are the parts that implement these international obligations into UK law. UK copyright can subsist if there's a qualifying connection, either through the author or through the work itself, linking it to the UK, its dependent territories, or any country designated by order in council as a convention country. These are essentially countries a party to the relevant treaties, and they are listed in orders under Section 159.
Okay, so how is that connection actually determined? What are the specific factors?
It depends on whether the work is published or unpublished at the relevant time, and whether you're looking at the author's status or the work's place of first publication.
Let's look at qualification by author first. How does that work?
Okay. If the work is unpublished, the author must have been a qualifying person at the time the work was made. If the work has been published, the author must have been a qualifying person either when the work was made or at the time of first publication. S.154 CDPA, considering S.159.
And what is a qualifying person?
A qualifying person is defined as an individual who is a citizen of or domiciled or resident in the UK or another convention country or a UK-dependent territory at the relevant date. For companies, it's based on being incorporated under the law of such a country and having a place of business there.
So an author's nationality, residency, or domicile at the point of creation, if unpublished, or first publication, if published, is key.
Yes. Now, qualification by work is often simpler. It generally asks, was the work first published in the UK or another convention country? That's under S.155 CDPA, again considering S.159.
What exactly counts as publication here? Does performing a play count?
Good question. Section 175 CDPA defines publication. It's based on an old case, Francis Day and Hunter v. Feldman & Co. It essentially means making copies of the work available to the public. But importantly, Section 175, subsection 4, specifies what does not count as publication for this purpose. Performing a play, playing music, showing a film, broadcasting a work, or exhibiting an artistic work does not count as publishing the underlying work itself in the sense of issuing copies.
That's a really important point. A public performance isn't the same as publication in the copyright sense of issuing copies.
Exactly. Also, there are rules for simultaneous publication in Section 155, subsection 3. If a work is published in a convention country within 30 days of being published anywhere else, like a non-convention country, it's treated as being first published in that convention country anyway. This prevents someone trying to avoid UK protection by publishing very briefly somewhere else first.
Do these author publication rules apply to all categories of work?
These specific rules apply primarily to literary, dramatic, musical, artistic works, and films, as these are the core works covered by the Berne Convention. Sound recordings use similar rules but align with the requirements of the Rome Convention. Broadcasts are different again. They only qualify based on the place from which the broadcast is made, S156, and printed editions qualify if the publisher is a qualifying person or if first publication took place in the UK or a convention country.
So, thanks to these international agreements and the CDPA implementing them, creative works from most countries around the world can automatically get UK copyright protection if they meet the other criteria, originality, fixation, category, based on a link either through the creator or where the work was first shared with the public by issuing copies.
That's the power and importance of national treatment in international copyright law.
Right. Section 6 in the source. Authorship and ownership. We touched on the critical distinction between author and owner right at the beginning. Let's get into the details now.
Yes, and just to reiterate that point, copyright ownership is entirely separate from owning the physical object embodying the work. Owning a painting doesn't automatically mean you own the copyright in the painting. The source mentions the Rhea Dickens case from 1935, where owning Charles Dickens' original manuscript letters didn't grant ownership of the copyright in the words of the letters.
Okay, so the basic rule for initial ownership, according to Section 11, subsection 1 of the CDPA, is pretty simple on the face of it. The author is the first owner.
That's the general starting point, yes. But there are very significant exceptions.
Yep.
First, Section 9 of the CDPA tells us who the author is for each category of work. For LDMAs and artistic works, it's usually the person who creates it, the writer, composer, artist. But for the entrepreneurial works like films, sound recordings, broadcasts, published editions, and importantly, computer-generated works, Section 9 has special rules, often designating the person who makes the arrangements for the work's creation, like the producer or publisher, as the author or the relevant figure for ownership and duration purposes.
So for a computer-generated work where there isn't a human creator in the traditional sense, the law designates the person who undertook the arrangements necessary for its creation as the author.
Exactly. Now, the really key exceptions to the basic rule that the author is the first owner are found in Section 11. The most common and important one is for employees, under Section 11, subsection 2.
Right. If a literary, dramatic, musical, or artistic work, or a film is created by an employee in the course of their employment, the employer owns the copyright initially, not the employee author.
This is a very common scenario in practice. The case law on what constitutes in the course of employment helps define this boundary. Cases like Stevenson, Jordan and Harrison v. McDonald and Evans and Belloff v. Pressgram Ltd. explore whether the work created was part of the employee's contracted duties. A useful test, suggested in Noah v. Schuba, asks, could the employer have lawfully ordered the employee to produce this specific work as part of their job?
So, if writing marketing copy is your job description, your employer owns the copyright in the copy you write during work time. But if you happen to write a screenplay in the evenings using your personal laptop based on your own ideas, it's likely still yours, unless your employment contract says something different, or maybe you used significant work resources or confidential information.
That's the principle, yes. The specifics of the employment contract are absolutely crucial here. Section 11, subsection 3 covers other specific scenarios, like Crown copyright for government works and parliamentary copyright.
Now, a really common point of confusion mentioned in the source is commission works. If I pay an artist to paint a picture for me, or I pay a designer to create a logo for my business, do I, the commissioner, automatically own the copyright just because I paid for it?
No, absolutely not. And this surprises many, many people. Under UK law, the commissioner does not automatically own the copyright just because they commissioned and paid for the work. A commission is simply an agreement where person A asks person B to create a work and agrees to pay for it unconditionally. That definition comes from Gabron v. Universal Music Operations Ltd.
Right.
Unless there is a specific written contract that explicitly assigns the future copyright ownership from the creator to the commissioner, which is allowed under Section 91 of the CDPA, then the initial copyright belongs to the author, the creator. So the artist or designer you commissioned owns it by default.
Wow. So if I paid good money for that logo and didn't get a written contract specifically mentioning copyright assignment, the designer still owns the copyright, not my business.
That is the default legal position, yes. Now, if the contract is completely silent on copyright ownership, the courts might be willing to imply terms based on business efficacy. Maybe imply an exclusive license for the commissioner to use the work for the intended purpose, or perhaps even imply that the commissioner has equitable ownership, a sort of beneficial ownership. But the initial legal ownership stays with the author-creator unless assigned in writing. The case R. Griggs Group Ltd v. Evans involving the Dr. Martens logo is a key one on this. It shows how implied terms are explored, but ultimately ownership depends heavily on the specific facts and what terms, if any, can realistically be implied.
So the absolute key takeaway for anyone commissioning creative work is get a written contract that explicitly assigns copyright ownership to you if you want to own it. Don't assume.
Yes, absolutely. Do not rely on default rules or hoping a court will imply terms later. Get it clearly stated in writing up front.
Very clear advice. What about joint authorship under Section 10 CDPA? When do multiple people count as joint authors of a single work?
Okay. Joint authorship applies when a work is produced by the collaboration of two or more authors. And crucially, their separate contributions cannot be distinguished from each other within the final, finished work. Let's repeat that definition. Collaboration where contributions are indistinguishable.
So if two people write different chapters of a book, that's not joint authorship because their contributions, the different chapters are separable, they are distinguishable.
Correct. Or if one person writes the music and another person writes the lyrics for a song, that's generally not joint authorship under UK law. They have separate copyrights and their distinct contributions. One musical work, one literary work. Joint authorship is where the contributions merge together into an inseparable whole. Think of two people co-writing dialogue together, line by line for a script, or perhaps collaborating so closely on designing a piece of software or a sculpture that you genuinely can't tell who did which specific part of the final expression.
And why is it important to identify whether something is a joint work or not?
Because specific rules apply to joint works regarding things like the duration of copyright is based on the death of the last surviving joint author, and also who needs to consent to the use or licensing of the work, or who needs to join together to sue for infringement. Usually all joint authors need to agree or be involved.
The case law has refined the definition of what actually counts as a contribution sufficient for joint authorship. It's not just having an idea.
No, definitely not just having the idea. The courts require each co-author to have shared responsibility for the form of expression and to have made a significant and original contribution to the creation of the work itself. Simply correcting errors in software wasn't enough in UoL Microsystems v. Key Radio Systems Ltd. Helping set up a database wasn't joint authorship as someone else did all the authorial work of selecting and arranging the content, as in Ray v. Classic FM Plantain. Musical cases like Hadley v. Kemp and Lawson v. Dundas saw claims for joint authorship fail because the court found the compositions were essentially complete before the alleged co-author got involved in performing or arranging them. And a theater director suggesting changes or cuts to a script wasn't considered an authorial contribution in Brighton and Doublejoint Co. Ltd v. Jones. Repeat, Brighton and Doublejoint Co. Ltd v. Jones.
So it needs to be more than just helpful suggestions or technical assistance. It has to be a contribution to the creative expression of the work itself, and it has to be significant and original.
Exactly. The leading modern case clarifying the criteria is Martin v. Cogan from the Court of Appeal in 2019. Let's remember that name. Martin v. Cogan. Floyd L.J. set out 4 conditions derived from the previous case law that need to be met. A, there must be collaboration. B, each contributor must qualify as an author. C, their contribution must be authorial in nature, not just ideas, significant and original. And D, the contributions must not be distinct or separate within the final work.
What about having the final say on the work? If one person has ultimate editorial control, does that prevent joint authorship?
Floyd L.J. specifically addressed this point in Martin v. Cogan at paragraph 51. He said that one person having the final say doesn't automatically prevent joint authorship, although it might be relevant evidence against true collaboration, or it might affect how the shares of ownership are divided later.
Interesting.
And the subsequent high court case, Cogan v. Martin, NOAA 2 from 2021, applied this Court of Appeal guidance. It found that providing the initial idea plus making significant suggestions for plot development, characterization, and dialogue were indeed authorial contributions to a screenplay, leading to a finding of joint authorship even though the other party had done the bulk of the writing and had final editorial control. So Kogan v. Martin note 2 is also important.
So how are the shares of ownership decided in a joint work? Is it always 50-50?
Well, traditionally, joint authors were said to hold the copyright as joint tenants, meaning they owned it together as one entity. Laurie v. Renaud is an old case on this. The presumption was often equal shares. However, courts are increasingly willing now to determine unequal shares based on the extent or value of each person's contribution. We saw this in cases like Fisher v. Brooker and Onward Music Ltd. Concerning the song A Whiter Shade of Pale, and Brown v. Micasso Music Productions Ltd. In Kogan v. Martin 9-2, the court assessed Mrs. Kogan's contribution at 20%. Section 1CD3 of the CDPA outlines the rights of joint authors between themselves.
Since there's no registration system in the UK, how do you actually prove you own the copyright if someone challenges it in court?
That can be a practical difficulty. However, Section 104 of the CDPA provides some helpful presumptions that can be relied upon in legal proceedings. For example, if the claimant states in their court documents that they are the owner and the defendant doesn't specifically deny it, the court can presume ownership. Or if a name purporting to be the author or publisher appears on published copies of the work, that name is presumed to be correct unless the defendant provides evidence to the contrary.
So these presumptions shift the burden of proof onto the defendant to disprove the claimant's title, which can be very helpful.
Exactly. They don't guarantee ownership, but they assist the claimant in establishing their case initially. Of course, having clear evidence like contracts is always the best way.
Absolutely. Okay, finally, Section 7 in the source material. Duration of copyright. How long does all this protection actually last?
Right. The rules were significantly affected by the EU Term Directive, which aimed to harmonize copyright terms across member states, generally by extending them. The current rules reflect that harmonization.
So for the main categories, literary, dramatic, musical, and artistic works, LDMAs and artistic, the standard rule now is the author's lifetime plus 70 years, right?
Correct. The copyright term runs until 70 years from the end of the calendar year in which the author dies. That's Section 12 CDPA. If the author is unknown, it's generally 70 years from when the work was created, or 70 years from when it was first made available to the public by authorized acts like publication or performance, if that happens within 70 years of creation. There's a specific shorter term for computer-generated works, 50 years from when the work was made.
What about songs where you have music and lyrics by different people? Are they treated together?
If they are considered separate works, a musical work and a literary work, then the duration for each part is tied to the life plus 70 years of its respective author, the composer for the music, the lyricist for the words. However, if the song is treated as a work of joint authorship for duration purposes, which is specifically provided for in Section 10A CDPA, then the term is 70 years from the death of the last surviving author, typically the survivor, the composer, and the lyricist.
Okay. Films have a similar rule based on the death of key contributors.
Yes, for films, the copyright lasts for 70 years from the end of the calendar year in which the last to die of certain specified people passes away. Those people are the principal director, the author of the screenplay, the author of the dialogue, and the composer of music specifically created for the film. That's Section 13B CDPA.
Sound recordings got a significant extension, didn't they? Especially relevant for performers and record labels.
They did, yes. This was a relatively recent change. The basic term is still 50 years from the end of the year the recording was made.
Yeah.
But if the recording is published or communicated to the public, like played publicly or made available online, during that initial 50-year period, the term is extended significantly to 70 years from the date of that first publication or communication. That's Section 13A CDPA. It gives much longer protection if the recording is commercially exploited.
Okay. Broadcasts, what's their duration?
Simpler. 50 years from the end of the calendar year in which the broadcast was made, S14 CDPA. And repeats of a broadcast expire at the same time as a copyright in the original broadcast did.
And finally, published editions, the typographical arrangement right.
This has the shortest term and was not affected by the main EU term directive changes. It's just 25 years from the end of the calendar year in which the edition was first published, S15 CDPA.
And just to echo the source's practical advice, especially for students, for clarity when learning these rules, it's generally simplest to assume works were created after the CDPA came into force in 1988, as the duration rules for works created before that date are different and quite complex, involving transitional provisions.
Yes, mastering the post-1988 rules is definitely the priority for understanding the current system.
So there we have it, a pretty deep dive into the fundamental requirements for copyright subsistence in UK law.
We've navigated that closed list of categories, exploring the nuances for literary, dramatic, musical, and artistic works, and also the distinct nature of films, sound recordings, broadcasts, and those typographical published editions.
We've definitely grappled with the crucial and evolving requirement of originality, contrasting the older UK skill and labor idea with the author's own intellectual creation standard brought in via EU law and interpreted by the CJEU in those pivotal cases like Infopack, Football to Taco, Painter, and Lavola Hengelo.
Mhm.
And we've seen how that tension plays out when you're considering things like revisions, adaptations, compilations, and even that tricky area of reporter's copyright from Walter V. Lane.
We've also covered the general need for works to be recorded in permanent form fixation, noting the exception for live broadcasts, and explained how international conventions ensure works from around the world can qualify for UK protection based on the author's or the work's connection to a convention country.
And we've clarified that absolutely vital distinction between authorship and ownership, looking at the basic rule. The critical exceptions for employees, and especially for commissioned works, remember the note for a written contract, and the specific requirements for joint authorship, guided by recent cases like Martin v. Kogan.
And finally, we've outlined the basic duration rules for different types of works, noting the impact of those EU harmonization efforts in extending terms for many categories. Understanding these building blocks, category, originality, fixation, qualification, authorship, ownership, and duration is absolutely essential. Without subsistence, without copyright existing in the first place, there's simply no rights to infringe.
Exactly. It all starts here. And just a reminder, this deep dive was based on educational materials provided by the University of London, intended purely for educational use, and was brought to you by Sinorbit Academy, Sri Lanka.
We truly hope that breaking down these concepts and walking through the key case law, repeating those names like Infopack, Football to Taco, Painter, Levela, Hensher, Lucasfilm, Walter V. Lane, Martin V. Kogan, has made this complex area a bit clearer for you. For everyone studying for exams, revisit these cases, really understand the principles they represent, and keep practicing applying these rules to different scenarios. You've put in the work, now trust your understanding. Good luck.
You absolutely have got this. And speaking of challenging definitions, as we've seen today, copyright law constantly stretches and adapts, sometimes awkwardly, to fit new forms of creativity from photographs to computer code to digital layouts. But what happens when creative expression becomes less about a fixed work and maybe more about a constantly evolving interactive digital experience or perhaps AI-generated content? How will the law define concepts like originality or fixation or even author then? It's a huge question, and one that the next generation of legal minds, maybe including you, will be grappling with.
It's a fascinating challenge for the future of copyright law.
Absolutely. Thanks so much for joining us for this deep dive.
Until next time.